So, good day everyone. So, I am Geraldine Lapiad. So, this is the continuation of Mr. Isidro's report with the topic of Rule 31 Real Property Taxation. So, first is the Article 355, the resale of real estate taken for taxes, fees, or charges. So the sanggunian concerned may, by a duly approved ordinance and upon notice of not less than 20 days, so sell and dispose of the real property acquired under the preceding article of public auction. So, the proceeds of the sale shall accrue to the general fund of the LGU concerned. So, if ang local government takes a property because the owner didn't pay taxes, fees, or charges, so they can sell the property through a public auction. So they must give at least 20 days notice before the sale. So the money earned from the sale goes to the LGU General Fund. So for example, no, so Juan failed to pay his property tax for several years. Because of this, so the local government of Buog took ownership of his land. After giving a 20-day public notice, the LGU held a public auction and sold the land of the highest bidder. So we already know no kung saan ang kanang magbidding-bidding. So kinsa to'y pinaka-highest ang gibid, so mapaiyaha uh, ang property nga i-auction. So the money from the sale was added to the LGU's general fund to help pay for local services and projects. So next is Article 356, further distraint or levy. So levy may be repeated if necessary on the same property subject to tax until the full amount due, including all expenses, is collected. So if someone still hasn't fully paid their taxes, no, so the government can keep seizing or levying the same property until the total amount, including extra costs, is fully collected. So for example, si Ana, he owes 10,000 sa taxes. So the local government seizes her motorcycle, but it only covers 6,000. So since Anna still owes 4,000, so the LGU can continue to levy the same property or take other assets until the full 10,000 plus kanang mga any added cost is ma-fully paid siya. So next is the Article 357. So collection of real property tax through the courts. So the delinquent basic real property tax or any other tax levied under this rule shall constitute a lawful indebtedness of the taxpayer to the LGU. So, if someone doesn't pay the real property tax, it becomes a legal debt to the local government. So, the LGU can file in court to collect the unpaid taxes. So collection of such indebtedness can be enforced through a civil action in any court of competent jurisdiction as follows. So here we have a subsection A. So the provincial or city treasurer or municipal treasurer of a municipality of MMA shall furnish the provincial attorney or city of or municipal legal officer a certified statement of delinquent who within 15 days after receipt so shall file the civil action in the name of the province, city, or municipality in the proper court of competent jurisdiction. So the jurisdiction of the court is determined by the amount sought to be recovered exclusive of interest and cost. Thus, where the delinquent tax due does not exceed 10,000 pesos, so the competent court is the municipal or city trial court, and where the amount due is in excess of 10,000 pesos, so the proper court is the regional trial court. So if someone doesn't pay the real property tax, so the local treasurer gives the legal officer a report of the unpaid tax. So the legal officer then has 15 days to file a case in court. So the court that handles the case depends on how much tax is owned. So if the unpaid tax is 10,000 or less, so the case goes to the kuan siya sa municipal or city trial court. So if the unpaid tax is more than 10,000, so the case goes to the regional trial court. So next is the subsection B. So where cognizable in an inferior court, so the action must be filed in the municipality or city where the delinquent property is located, where the regional trial court has jurisdiction. So the plaintiff LGU shall file the complaint in the city or province where the property is situated. So if the case is handled by a lower court or the municipal or city trial court, so it must be filed in the same city or town where the unpaid property is located. So if it's a regional trial court case, it should be filed in the city or province where the property is found. So, for example, Carlos owns land in Buog and owns 7,000 in taxes. So, since this is under the 10,000, so the case is filed in the municipal trial court of Buog. So, if si Maria owes 20,000 thousand in taxes. So on a property in Zamboanga City, so the case must be filed in the regional trial court of Zamboanga City. So if lower lang siya, so kung sa buog man galing na kung sa buog siya na nagpuyo, so dito ra pod kanang i-resolve bitaw ang problem or dito siya mag-file sa ihang case. So, if above siya sa 10,000, so which is Maria nag-owe siya og 20,000 sa iyang property is naa sa Zamboanga City. So dito pod siya mag-case og filed sa Regional Trial Court sa Zamboanga City. So next, the subsection C. So in both cases, that is where the claim is either cognizable by an inferior court or by the regional trial court, so the provincial or city treasurer shall furnish the provincial attorney or the city or municipal legal officer concerned the exact address of the defendant where he may be served with summons. So, no matter which court will handle the case, so the local treasurer must give the legal officer the exact address of the person who owes taxes so they can receive the court notice or summons. So, if for example, si Juan has unpaid property taxes, so the city treasurer gives the legal officer his home address in barangay, for example, iyang home address kay sa barangay Poblacion. So the court can send him a summons and inform him about the case. So let's proceed to the Article 358, action assailing validity of tax sale. So subsection A, the court shall entertain any action assailing the validity of any sale of at public auction of real property or rights therein under this rule until the taxpayer shall have deposited with the court the amount for which the real property was sold, together with interest of 2% per month from the date of sale to the time of the institution of the auction. So the amount so deposited shall be paid to the purchaser of the auction sale if the deed is declared invalid, but it shall be returned to the depositor if the action fails. So if a taxpayer wants to challenge a public auction sale of their property in court, so they must first deposit the full sale amount plus 2% interest per month. So from the sale until they file the case. So for example, if the court finds that the sale is invalid, so the buyer gets the money. So if the court says the sale is valid, so the taxpayer gets the deposit back. So for example, si Lisa's property was sold at auction for 50,000. So she wants to question the sale in court. So to proceed, she must first deposit the 50,000 plus the 2% interest per month since the sale. So if the court says that the sale was not valid, so the buyer gets the 50,000 and interest. So if the court says that the sale was legal, so Lisa gets her deposit back. Next is the subsection B. So no court shall declare a sale at public auction invalid by reason of irregularities or informalities in the proceedings unless the substantive rights of the delinquent owner of the real property or the person having legal interest therein have been impaired. So a court will not cancel a property auction. A court will not cancel a property auction sale just because of small mistakes in the process, unless those mistakes seriously harm the rights of the property owner or someone with a legal interest. Si Lisa if Lisa's land was sold at auction and the notice was 1 day late, so the court won't cancel the sale unless Lisa can prove that this delay harmed her rights, like not giving her enough time to stop the sale. So, let's proceed to the Article 359, payment of delinquent taxes on property subject of controversy. So in any action involving the ownership or possession of or a succession to real property, the court may a motu proprio or upon representation of the provincial, city, or municipal treasurer or their respective deputies, award such ownership, possession, or succession to any part to the action upon payment to the court of taxes, with interest due on the property and all other costs that may have occurred, subject to the final outcome of the action. So if there is a court case about who owns or should get a piece of property, so the court can let a party take ownership or possession if they paid unpaid property taxes or the interest and other costs. But this decision is temporary lang and depends on the final resort of the case. So for example, Anna and Ben are in court fighting over who owns a piece of land. So kani siya no, grabe kani siya nga kuan diri sa kanang maigsoon yung magilugay sa land. So while the case is still ongoing, so the court allows Anna to take temporary possession of the land because she paid the 12,000 in unpaid taxes and fees. However, the final decision will still depend on who the court declares as the rightful owner. So let's proceed to the Article 360, certification of local treasurer or delinquencies remaining uncollectible. So the provincial city, or municipal treasurer or their deputies shall prepare a certified list of all real property tax delinquencies which remain uncollected or unpaid for at least 1 year in his jurisdiction, and a statement of the reason or reasons for such non-collection or non-payment, and shall submit said documents to the sanggunian concerned on or before December 31st of the year, immediately succeeding the year in which the delinquencies were incurred, with a request for assistance in the enforcement of the remedies for collection provided in this rule. So every year, no, so the local treasurer must prepare a list of unpaid property taxes that have been overdue for at least 1 year. So this list should explain why the taxes haven't been collected and be submitted to the local council or the sanggunian by December 31st of the following year. So the treasurer will ask for help in enforcing ways to collect the unpaid taxes. Next is the Article 361 periods within which to collect real property taxes. So the basic real property tax and any other tax levied under this rule shall be collected within 5 years from the date they become due. So no action for collection of the tax, whether administrative or judicial, shall be instituted after the expiration of such period. In case of fraud or intent to evade payment of the tax, such action may be instituted for the collection thereof within 10 years from the discovery of such fraud or intent to evade payment. So the real property taxes must be collected within 5 years from when they are due. So after that, no legal action can be taken to collect them. However, if the taxpayer fraudulently avoided paying the taxes, so the government can still take action to collect the taxes within 10 years from when the fraud is discovered. So the period of prescription within which to collect shall be suspended for the time during uh, which subsection A, the local treasurer is legally prevented from collecting the tax. So if the local treasurer is unable to collect the tax because of legal reasons like a court order, so the time limit to collect the tax is mapos siya. Subsection B, so the owner of the property or the person having legal interest therein requests for investigation and executes a waiver in writing before the expiration of the period within which to collect. So, if the property owner asks for a review of their case and agrees in writing to extend the collection period, so the time limit is paused until the review is done. Next is the subsection C, so the owner of the property or the person having legal interest therein is out of the country or otherwise cannot be located. So if the property owner is outside the country, so outside the country or cannot be found, so the time to collect tax is suspended until they can be reached. So let's proceed to the Article 362, the distribution of proceedings. So we have here a subsection A. So the proceeds of the basic real property tax, including interest thereon, and proceeds from use, lease, or disposition, sale, or redemption of property acquired at the public auction, and 50% of the tax paid under protest collected by the local treasurer shall be distributed as follows. So first, in the provinces level, so provincial share. So the provincial share, there is 35% shall accrue to the general fund, while the municipal share, uh, it has 40% shall accrue to the general fund and of the municipality where the property is located. Next is in the barangay share, there has 25% shall accrue to the barangay where the property is located. Next is in the cities naman. So city share, so 70% shall accrue to the general fund of the city. Barangay share, there is 30% shall be distributed among the component barangays of the cities where the property is located in the following manner. So We have again the subsection I. The 50% shall accrue to the barangay where the property is located, and the 50% shall accrue equally to all component barangays of the city. So next is the municipality within MMA. So the Metropolitan Manila Authority share, so 35% shall accrue to the general fund of the authority, while in the municipal share, 35% also shall accrue to the general fund of the municipality where the property is located. In the barangay share, there are 30% shall be distributed among the component barangays of the municipality where the real property is located in the following manner. So the 50% shall accrue to the barangay where the property is located, same as the sa cities, and 50% shall be accrue equally to all component barangays of the municipality. So let's proceed to the subsection B. So the share of each barangay shall be released directly to the barangay treasurer on a quarterly basis within 5 days after the end of each quarter. So without need of any further action, and shall not be subject to any lien or holdback for whatever purpose subject to such rules as may be prescribed by COA for this purpose. So each barangay now will receives its shares of the taxes directly from the government every quarter. So the payment must be made within 5 days after the end of each quarter. So there will be no delays or deductions, and the money is not subject to any legal claims or holds. So unless there are rules set by the Commission on Audit. Let's proceed to the Article 363, the application of proceeds of the additional 1% special education fund tax. So we have here the subsection E, A, B, and C. So the proceeds of the additional 1% real property tax accruing to special education fund shall be automatically released to the local school boards. So in B, in case of provinces, the proceeds of the special education fund shall be divided equally between the provincial and municipal school boards. C. Said proceeds shall be allocated as determined and approved by the local school board concerned only for the following purposes. So number 1, operation and maintenance of public schools. 2, the construction and repair of school buildings, facilities, and equipment. And lastly, third is educational research. Fourth is purchase of books and periodicals, and 5, sports and development. So let's proceed to the Article 364, proceeds of the tax on idle lands. So the collection of additional real property tax on idle lands shall accrue to the respective general fund of the province or city where the land subject to tax is situated. In the case of municipality within MMA, so the same shall accrue equally for the Metropolitan Manila Authority and the municipality where the land is situated. Accordingly, the proceeds of this tax shall be treated in the income account as revenue from taxation. So the tax collected on idle lands or the land not being used goes to the general fund of the province or the city where the land is located. So for municipalities in the Metropolitan Manila area, so the funds are shared equally between the Metropolitan Manila Authority and the municipality. So this tax is treated as revenue in the government's income account. Next is Article 365, proceeds of the special levy. So the proceeds of the special levy lands benefited by public works projects and other improvements shall accrue to the general fund of the LGU which finance such public works projects or other improvements. So accordingly now, all income derived from this special levy shall be treated in the income account as revenue from taxation. So the tax collected from lands that benefits from public works or improvements goes to the general fund of the local government unit that finance those projects. So this money is treated as revenue from taxation in the government's income account. Next is the Article 366, the General Assessment Revision, expenses incident thereto. So subsection A, so the sanggunian of provinces, provinces, cities, and municipalities within MMA shall provide the necessary appropriations to defray the expenses incident to the general revision of real property assessment. So the local government or the sanggunian of provinces, cities, and municipalities must set aside money to kanang cover the cost of revising property assessment. Subsection B, all expenses incident to a general revision of real property assessments shall, by ordinance of the Sangguniang Panlalawigan, be apportioned between the province and the municipality on the basis of the taxable area of the municipality concerned. So the cost of revising property assessments will be shared between the province and the municipality based off the size of the taxable area in the municipality. Next is the subsection C. The barangays may be required by the sanggunian of a city or municipality to share in the expenses to be incurred for the conduct of general revision of real property assessments. So the barangays now may also be asked to contribute to the cost of revising property assessments as determined by the city of municipality. Next is the Article 367, the condonation or reduction of real property tax and interest. In case of a general failure of crops or substantial decrease in the price of agricultural or agri-based products, or calamity in any province, city, or municipality, so the sanggunian concerned by ordinance passed prior to the first day of January of any year and upon recommendation of the local disaster coordination council may condone or reduce wholly or partially the taxes and interest thereon for the succeeding year or years in the city or municipality affected by the calamity. So if a province or city or municipality now faces a kind of disaster or crop failure or a drop in agricultural prices, so the local government or the sanggunian can, upon recommendation from the local disaster coordination council, to reduce or cancel property tax and interest for affected areas. So this decision now must be made before January 1st of the year it applies to. So let's proceed to the Article 368, the condonation of reduction of tax by the President of the Philippines. So the President of the Philippines may, when public interest so requires, condone or reduce the real property tax and interest for any year in any province or city or municipality within MMA. So the President of the Philippines now can reduce or cancel property taxes and interest for any a year in a province, city, or municipality within the metropolitan Manila area if it's needed for the public interest. So next is the Article 369, duty of registrar of deeds in the provincial, city, or municipal assessor. So notaries public to assist. It shall be the duty of the registrar of deeds and notaries public to furnish the provincial, city, or municipal assessor with copies of all contracts, contract selling, transferring or otherwise conveying, a leasing or mortgaging real property received by or acknowledged before them. So the registrar of deeds in notaries public must provide the local assessor with copies of all the contracts related to the sale, transfer, fees, or mortgage of real property for transparency. So next it is the Article 370 duty of insurance companies to furnish information to local assessors. So insurance companies are hereby required to furnish to provincial, city, or municipal assessor copies of any contract or policy insurance on buildings, structures, and improvements insured by them or such other documents which may be necessary for the proper assessment thereof. So the insurance companies must send the local assessor copies of any kanang insurance contracts or policies for buildings and properties so the assessor can properly value them for taxes. So, next is the Article 371 fees in court action. So, all court actions, criminal or civil, instituted at the instant of the provincial, city, or municipal treasurer or assessor under the provisions of this rule shall be exempt from the payment of court and sheriff's fee. Excuse me, sheriff's fees. So when the local treasurer or assessor take legal action to collect taxes, so they don't need to pay court or sheriff's fees. Next is the article. Tas pa ba? Tas pa jud. Next is the Article 372 fees and registration of papers or documents on sale of delinquent real property to provinces, cities, or municipalities. So, all certificates, documents, and papers covering the sale of delinquent property to the province, city, or municipality, if registered in the registry of property, shall be exempt from the documentary stamp tax and registration fees. So, the document related to the sale of delinquent properties to the government, the province, city, or municipality, so are exempt from documentary stamp tax and registration fees. Next is Article 373, the real property assessment notices or owner's copies of tax declarations to be exempt from postal charges or fees. So all real property assessment notices or owner's copies of tax declarations sent through the mails by the assessor shall be exempt from the payment of postal charges or fees. So the real property assessment notices or tax declarations sent by the assessor through the mail or through the mail are exempt from postal fees. Next is Article 374, sale and forfeiture before effectivity of the code. So the tax delinquencies incurred and sales and forfeitures of delinquent real property affected before the effectivity of the code shall be governed by the provisions of the applicable laws with adding in force. So if the property taxes were due and properties were sold or forfeited before the tax code was enforced, those cases are still governed by the laws that were in effect at the same time. Next is the Article 375, the penalties for omission of property from assessment or tax rules by officers in other acts. So any officer charged with the duty of assessing a real property who willfully fails to assess or who intentionally omits from the assessment or tax rule. So any real property which he knows to be taxable or who willfully or negligently underassesses any real property or who intentionally violates or fails to perform any duty imposed upon him by law relating to the assessment of the taxable real property shall upon conviction be punished by imprisonment of not less than 1 month for not more than 6 months or by a fine of not less than 1,000 pesos nor more than 5,000 pesos or both such imprisonment and fine at the at the discretion of the court. So the same penalty shall be imposed upon any officer charged with the duty of collecting the tax due on real property who willfully or negligently fails to collect the tax and institute the necessary proceedings for the collection of the same. So of the same. So, any other officers required by this are ruled to perform acts relating to the administration of the real property tax or to assist the assessor or treasurer in such administration who willfully fails to discharge such duties shall upon conviction by punishment be punished by administration who willfully fails to discharge such duties shall upon conviction be punished by imprisonment of not less than 1 month, nor more than 6 months, or by a fine of not less than 500 pesos, nor more than 5,000 pesos, or both such imprisonment and fine at the discretion of the court. So, to understand it shortly, no, so government officials who intentionally fail to assess property or assess it, so or who don't do their duties related to property taxes can be fined or imprisoned for up to 6 months. Next is the Article 376, the penalties for delaying assessment of real property and assessment appeals. So, any government officials who intentionally and deliberately delays the assessment of real property or the filing of any appeal against its assessment shall, upon conviction, be punished by imprisonment of not less than 1 month, same as Article 375, not more than 6 months, or by a fine of not less than 500 pesos, nor more than 5,000 pesos, or both such imprisonment and fine at the discretion of the court. So, government officials who deliberately delay property assessments or appeals can face a fine or imprisonment for up to 6 months. So lastly, we have the Article 377, the penalties for failure to dispose of delinquent real property of public auction. So the local treasurer concerned who fails to dispose of delinquent real property at public auction in compliance within the pertinent provisions of this rule, and any other SU officials who acts hinder the prompt disposition of delinquent real property at public auction shall, upon conviction, be subjected to imprisonment of not less than 1 month, nor more than 6 months, or a fine of not less than 1,000 pesos, so mas higher siya, nor more than 5,000 pesos, or both such imprisonment and fine of the discretion of the court. So, if a local treasurer or other officials don't sell delinquent properties of auction as required by law, so they could face imprisonment or a fine for up to 6 months. So that would be all, and thank you.